Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Bright versus State of Florida and Bright versus Secretary, Department of Corrections, numbers 2023-1735 and 2024-0876.
Good morning. My name is Elizabeth Spiaggi on behalf of appellant and petitioner, Mr. Bright.
I apologize. Do you mind, can you raise that and speak
Absolutely.
up a little bit?
Is that better? Okay.
Thanks.
All right. All right. Mr. Bright went through a prior post-conviction proceeding after his 2009 trial. He was granted a new penalty phase, and we are here on the appeal of the denial of relief for that penalty phase in post-conviction. Additionally, we have Mr. Bright's state habeas, which addresses some issues from the penalty phase and some issues from his 2009 trial. I would like to focus first on the ineffective assistance claim relating to trial counsel's investigation of mitigation. Firstly, dealing with her failure to investigate Mr. Bright's military career. Trial counsel testified that she never looked into calling folks who had served in the Marines with Mr. Bright and never identified this as an area of inquiry for her investigator. The veterans who testified at the evidentiary hearing who had served with Mr. Bright painted a compelling picture of a diligent, hardworking, selfless Marine. They talked about the stress of that particular MOS, the military occupational specialty. They explained that in keeping these aircrafts running, the pilots' lives depended on them, and they were under a lot of pressure to sort of keep an available number of Harriers, that's the aircraft he worked on specifically, up and running. They talked about the physically grueling conditions in Cherry Point, North Carolina, and Yuma, Arizona, as well as on the carriers when they were at sea. At sea?
Can you point particularly to what effect this would have had?
So the jury did not hear anything about Mr. Bright's day-to-day doings in the military. They did not hear how stressful this particular occupational specialty was. There was really no humanizing of that military service in the presentation that was done. They had a fellow colleague, another attorney, read Mr. Bright's military records to the jury. So the jury really didn't get a sense of what he was doing in the day-to-day or hear from other people who had served with him. And I think it's very important because there's sort of a misconception that if you're not actively deployed in combat, military service isn't that stressful. But I think their testimony countered that and sort of corrected that idea that even in maintaining these maintaining the aircrafts, there were casualties in training. And the mechanics were sent to pick up the pieces of the plane.
What kind of
and the remains.
Do you think that this would have resulted in?
Well, as it was, Mr. Bright's, the sentencing court gave little weight to Mr. Bright's military career.
And we already reviewed that the original time, right, in 2020?
At that point, you didn't know what testimony was missing that would have impacted that.
In 2020, there was a little weight given to military service, correct?
Yes, right.
Right. And we said that that would not have outweighed the aggravating factors.
What I'm saying is that I think it deserves a lot more than little weight. I think that finding is an anomaly, especially when you hear about how dangerous his service was and how respected he was by his fellow Marines for his work and his willingness to help them.
Well, then it sounds to me like you're conceding that you want us to reweigh the evidence.
I am saying that there's not competent, substantial evidence to support the circuit court's finding in this instance. The circuit court found that trial counsel had made a reasonable strategic decision in presenting a witness who didn't know much about Mr. Bright's military career. I think just in sort of saying that to you, you can see how illogical that is.
Well, wasn't she concerned that there were things that happened, other things that happened at that time that would open the door for all of those questions to come out as well?
I think what we saw at the evidentiary hearing is that actually none of these witnesses knew much about Bright's transgressions. They were not part of the bigger picture of his military career. And so I think it actually would have refocused the presentation on what he actually did rather than allowing the state to make completely unfounded arguments about his career. There were for one example, I think the state argued that Mr. Bright was sleeping in the place where they worked on the planes, and at the evidentiary hearing, it came out that no, the write-up for him sleeping was for when he was in the dorm monitoring other people who lived on base in the dorm. So I think that's a big distinction between what the prosecutor's arguing and the picture that the prosecutor is trying to paint versus his actual service. And by relying on just the records, she wasn't able to sort of correct and counter that depiction. She herself, it seemed, didn't have a thorough understanding of those records because that particular write-up, I mean, it was right there. She relied solely on the colleague to testify and help her prepare. And I think what we pled was that she really needed somebody to help her gather these first-person witnesses who had served with him and had, actual testimony about what Mr. Bright had done with them. And if she had had an expert to help her organize those and to sort of better understand the records, it would have resulted in a different amount of weight that was given to this military service.
So do you consider this your strongest claim?
I think that the failure to investigate mitigation is the strongest claim. I think that the other part of that is also giving the jury some context of what happened in the guilt phase of this. And this is sort of typical in a penalty phase, that they will educate the jury on the basic facts of the crime, but it really didn't even happen here. So we also alleged that she should have called two of the state witnesses from the guilt phase, Mr. Brian Williams and Mr. Benjamin Lundy, who for one thing, they provided additional mitigation testimony about, again, what a diligent, hard worker Mr. Bright was and how clients asked for him specifically because they knew that he was the best at his job and that he would take great care in his work. But they also knew about the circumstances that were going on in Mr. Bright's house. They had testified in the original trial for the state that the victims were selling drugs out of Mr. Bright's home and keeping firearms there. But
this goes to the entire strategy that trial counsel testified to, correct? That she made a very intentional choice that they were not going to victim blame.
I don't think it's victim blaming. I think you have to remember that the jurors are looking at what I will admit are fairly gruesome pictures, and they need to understand how these events occurred. They need to be put into context of the crime.
And you are not, I mean, the strategy was there's, I think, 16-year-old, is that right?
I believe one 17-year-old and a 19-year-old.
A 17-year-old and a 19-year-old were murdered. And she said, as a strategy, I'm not going to go to any of their potential misdeeds and blame them. I think a better strategy is to sort of plead for mercy and follow that path. So every single thing that you argued in your brief, 5 points, goes to that issue. So why do you think that that was an ineffective strategy?
Well, I believe there was a lot of talk from the court about victim blaming, but what trial counsel actually testified to was, I wanted this jury to know that I respected the prior jury's verdict. And to me, I can't make a lot of sense out of that. You're not telling the new jury that he's not guilty. You are simply providing background. I think her other, it's also about giving some insight into Mr. Bright's fear of the victims, which is something that the jury's absolutely allowed to consider. They're instructed to consider the circumstances of the crime. So I think she did a real disservice to Mr. Bright in not, I realize it's a careful balancing act to not villainize the victims, but at the same time, you have to provide some insight into what was going on in the house, that Mr. Bright was being threatened, that he had contacted law enforcement, that this was an escalating situation in his home to try and get these guys out of there, to stop running basically a drug house out of his home. And the folks who worked with him would have testified in the original trial as state witnesses, in the guilt phase, that his demeanor was changing. He had this mounting anxiety over these guys being in his home. I believe his sister testified to his childhood stutter reoccurring. So everyone sort of painted this picture of Mr. Bright really as at the mercy of these two guys who had sort of taken over his home. I think I'd like to address an issue from the state habeas, that being the improper prosecutorial argument that was made, that the jury should show Bright the same mercy he showed the victims. This was a very clearly preserved error in that counsel filed a motion in limine about, in order to forbid the prosecutor from making this type of argument. The motion in limine was granted, and an order was issued that he could not make these arguments. He made them. She objected. The judge overruled the objection and later acknowledged, oh, this was the issue from the motion in limine. So it was a preserved error, and it was not raised on appeal. I think this pretty squarely fits the ineffective assistance of appellate counsel. It's a preserved error that's meritorious. This court has reversed before on this argument. There's a good amount of case law forbidding this type of argument.
You have a case in which we have reversed on that alone?
I don't think you would be reversing on that alone, because on direct appeal she raised on direct appeal appellate counsel raised other inappropriate arguments that were made by Mr. De La Rionda, and I think the other arguments were not preserved, so she was appellate counsel was arguing fundamental error. But when you combine that with the preserved error of the same mercy argument, you've certainly reversed on same mercy in addition to
we already find that those were not in error? We already affirm?
No, because it wasn't raised on direct appeal. That's the claim, that appellate counsel was ineffective.
Right, but the other issues.
I'm talking about together, right? Doing a cumulative analysis. It was ineffective of appellate counsel not to have raised it with the other improper arguments that she did raise.
I'm sorry, which of the 17 issues you raised is the same mercy comment?
This was the improper prosecutorial argument that was raised in the state habeas.
No, of the 17 issues in your brief,
yes,
which one is the same mercy argument?
I don't think we raised it in the brief. It's just in the state habeas.
So why are we talking about it?
Well, I'm also here on his state habeas.
Okay, so is it raised in that as well?
Yes, sir.
Okay, so I guess this goes to a larger point, which is help us sort wheat from chaff.
I think what really needs to happen is that the prosecutors, maybe they need to be they need to be given some guidance, because this is a very clearly impermissible argument. I'm not going to ignore.
Please don't change the subject.
Yeah, I'm not trying to change the subject. I feel I would be ineffective if I did not raise what are meritorious arguments. We have a duty to bring these claims in state court and make sure that they're ruled on if they have merit, which a large number of these do.
Can you point us to the one that you believe has most merit?
I think we're talking about it clearly. I think we're talking
The
about it
same
presently.
mercy argument is if you were going to pick the basis for a reversal here, you would rest your case on the same mercy argument?
I think it's dispositive for the penalty phase in that it was clearly ineffective of appellate counsel not to raise the preserved error. Under prevailing norms, appellate counsel should raise claims that have already been determined by this court in the sense that it's already been ruled on a lot that you can't make this argument.
But where is the prejudice if we don't reverse on that alone? Then where would the prejudice factor fall?
Well, I think what we have here is we have trial counsel not presenting a very full picture of mitigation. She didn't investigate, and then we have, in addition, the prosecution making impermissible arguments. So, all in all, it's very damning for Mr. Bright. But I see I'm into my rebuttal time, so I will save the rest of my arguments for that.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Jason Rodriguez, Assistant Attorney General for the state of Florida. In my time before the court, I will explain why this court should both affirm the denial of post-conviction relief and deny Bright's state habeas petition. Whereas I want to begin where we began with Mr. Bright, which was the military mitigation claim. And what's very clear, both based on the trial court's or post-conviction court's findings and counsel's testimony, is that counsel knew there was a lot of bad in those military records and made a strategic decision. I've got one buttoned-up witness that can present a good case to the jury. I know him. He's a former Marine JAG officer. He comes across very well. He speaks very clearly. And I want him to be the one to present all of this military mitigation to the jury rather than trying to go and find other individuals that might end up wandering into territory that I don't want to touch. Some of the military witnesses down below did know some of Bright's issues, including about court-martial, drinking, and things of that nature. So counsel made a reasonable strategic decision. We don't, in post-conviction, nitpick everything counsel does. Is it reasonable for an attorney to do that? And that's reasonable trial strategy. Regarding the context of the House, we again come into another very reasonable trial strategy. The state's position is not that no attorney ever could choose to take the route that post-conviction counsel is suggesting. It's that a reasonable attorney could choose not to take that strategy. And when we're talking about, and my recollection is it's a 16-year-old and a 20-year-old, that strategy is incredibly reasonable, and counsel affirmatively tried to exclude evidence of the younger victim's age and was unsuccessful in doing so. So counsel knew she had a problem on her hands and wanted to avoid anything at all that was going to look like she was blaming the young victims for their deaths. She said,
let me ask you about that. What did trial counsel specifically say, indicating in the evidence you're hearing that she was pursuing a strategy that involved avoiding blaming the victim?
So she said, and this is a quote, and I'd have to look at my notes that are over here, but she said, quote, "It would be a bad move to blame the victims," was one of the things that she said. She said that, I'm asking for mercy for Mr. Bright, who did terrible things, and I didn't think it would be a good idea to, go the opposite way with the victims and make it sound like they're responsible for their deaths. But her testimony on that issue is very clear. In the record. I think it mostly comes out in the state's cross where she's asked those specific questions, but it's very clear that that's exactly what she was doing. Moving to the same mercy issue very briefly. So one, this court has said in Merck that it doesn't reverse on same mercy comments alone. And by and large, the comments that were raised, the prosecutorial comments that were raised on direct appeal, this court found there was no error in them, with one exception. That one exception was that the prosecutor in closing said mitigation had to be proven to a reasonable certainty. That is the only comment that I'm aware of that this court found any error in at all, and it said it was entirely cleared up by the jury instructions. The prosecutor made a one-off offhand comment, and the jury instructions would have entirely cleared that up. So in that circumstance, when we're combining what's kind of a half same mercy comment with a totally cleared up by the jury instruction comment, we're really in the same position as Merck, where a same mercy standing alone would not be a reversible error. States argued in its brief that this court should recede from its same mercy case law based on really the majority view of courts, including from the 11th Circuit, that have said this is really a totally proper comment, that when a defense counsel is able to get up and argue, you should show mercy on my client, the state is able to rebut that position by saying, show him the same mercy that he showed to the victims, and reminding the jury that mercy to the defendant is not the only thing that's on the table, but we look at the victims as well. And that is the majority view, including the view held by the 11th Circuit. Your Honors, if you have no more questions, and I know issue 12 Guardado was raised, but if the court does not have any questions, then I'll stand on my brief. All right. Thank you, Your Honors.
Thank you.
Well, I'll try not to belabor any of my previous points. As for strategic decisions, in order to make an informed strategic decision, you have to investigate the case. So before, she can't decide without talking to people who served with Mr. Bright that it would be better for them not to testify. That's not an informed decision based on her investigation. The same is true, I would say, of the contextualizing the crime. Her co-counsel testified that they didn't look into this area. Her work product shows that she didn't research whether she could contextualize the crime. So even that decision, she was not an informed decision based on research. I would also, as far as the military mitigation, I would point this court to Porter, where the U.S. Supreme Court specifically held that even if there are transgressions in someone's military service, you have to present that full picture, because even with the transgressions, they're sort of overshadowed by the service to our country. And I would point out that in Porter, the transgressions were pretty big. I think he was AWOL for 6 months. Lesser so in Mr. Bright's case. In closing, I would just say that trial counsel's testimony about her strategies is contradicted and undercut by her co-counsel, her investigator, and the record from the penalty phase itself. I would ask this court to reverse the circuit court's denial of post-conviction relief, as well as grant a new appeal of his full trial based on the issues raised in the state habeas.